Hello, it's Philip Taylor from Richmond Green Chambers. I'm talking about an interesting book. It's quite a heavy book. It's from the Sweeton Maxwell Common Law Library, and it's known as Phipson on Evidence. It's the ultimate statement on the law of evidence, and I've given it a title on the internet and in the reviews I've written in the Barrister and various other journals: Seriously Good Advocacy for the Law of Evidence. The edition's edited by Hodge Malik and a large team of people, and it's an excellent book. Now, the book first appeared around about the time of Mrs. Carlyle having trouble with her smoke ball in 1892, and Sidney Phipson's aim was to obviously give a statement of the common law in particular at that time. Now, the Sweeton Maxwell Common Law Library, of course, provide the ultimate statement and what we have at the moment as the law in various important areas, and this is one of them. The 15th edition, obviously now with updates, maintains in my view the very highest standards of their library, and the simple truth is that what we know as Phipson on Evidence is the best book available for both practitioners and academics. Lawyers know that the problem with evidence is the changing nature of the subject with which it's associated. There's massive case law, and there are continual attempts by obviously Parliament in particular to have full codification. Obviously it's a main piece of legislation set over periods of time that is what we need, but we haven't got there yet. The question is, what are the changes with this latest Phipson? Because they get out of date, these books, quite quickly if you're not careful. Uncomfortably, probably for many people, rather too much of the pace of reform has finally quickened with the introduction of CPR in 1999 and their criminal partners, the criminal procedure rules, in 2005, which are nicely covered in Blackstone's guides and also, of course, referred to here. Hodge Malik, the main editor, says of Phipson that the new rules, quote, open with overriding objectives which colour the interpretation of the procedural rules generally. I've certainly found the guides that we have concerning the rules very helpful, and I actually have to use some of the information in tandem with Phipson. What I could say about this book is that there's a lot of information. The main point, from what I can see of the work, is that the Criminal Justice Act 2003 is now fully implemented and brilliantly covered. Obviously there are a large number of changes. We're moving very much forward now from that period of time in the first decade of the 21st century, obviously into 2010 and beyond, and we have to look ahead and see what's going to happen then. We started this great adventure with the arrival of the new rules and some of the sort of common sense explanations that occur in Phipson, certainly on things like hearsay and character evidence, are very good. I've used this extensively with my teaching, certainly at university level, with undergraduates at the University of London, and I find it very helpful. Obviously you've also got to now consider the Human Rights Act with everything that you do, and Phipson covers that well. So I think we can say it's proof enough that on the evidence Phipson has no near contender for sheer depth and breadth of its task. And obviously you can see that with what's contained in this new edition, and many of course will remember previous versions. The new edition has been of course completely rewritten, which is inevitable I think with this subject, although the structure remains largely the same. With the 15th edition there are 44 chapters, each chapter being written by an expert in the field, which is very much in tune with the sort of thing that Sweeton Maxwell have with this common law library. And I believe it's the essential tool, of course, in terms of reference for both the practitioner and the academic. I found the academic references extremely useful with my teaching, because obviously when I teach evidence, it's about the practical application of the rules, and then the issues which we can then argue about what might or might not be the case. And obviously you have to get up to a certain level of knowledge with evidence before you can start speaking with any form of authority. So I think it's right to say that Phipson helps you in every situation related to evidence, whatever you are, whether learner, practitioner or academic. It has an excellent team of authors as well, and obviously one of the things I'm always fascinated by is that I'm asked as a politician, where do you find the law? Where do you get the law from my constituents? And the answer is quite simple. You get it from things like Phipson and of course Halsbury. There are obviously other common law library editions published by the Sweet and Maxwell group, and they cover all the main areas, but this one stands out to me as one of my little favourites, if you like, going back over the last 40 years of my legal connection and involvement. Obviously I've mentioned some of the other publications in other parts of the reviews that I've done, Chitty for instance on contracts and so forth. There's an interesting comment by Robert Walker which I'll finish on, and that is, he says that this is a venerable work. It's a good foreword that he writes it, but he then spoils it by reminding us that there were other highly regarded textbooks on evidence in the 19th century which obviously could be considered. Fact is that Phipson has continued. It's actually succeeded, whereas others have fallen by the wayside. It has the lasting power, therefore, and it does make, in my view, its own contribution to the development of the law of evidence as we now see it, because it bravely ventures into fields like equitable estoppel, where no book has possibly boldly gone before. So to me, the modernisation of the well-discarded Criminal Evidence Act 1898, changing notions of fairness under the CJA 2003, and various other things have helped. Walker says this: evidence has ancient roots which are today barely discernible under the ramifications of centuries of common law development and statutory reform, some of it of a drastic nature. In fact, we've had to be drastic, because the punishments in the 19th century to fit the crimes are totally different in comparison with what we have today. And it's certainly an area where I would see, as this century develops, where we may have to be addressing some of the major issues again. One of the biggest ones could well be the standard of proof, certainly in criminal cases. Leave that thought with you. Thank you very much. Do have a good look at it. Bye bye.